exported, they
Yeah,
don't have to disclose that their information is being disclosed then anytime we do an export to RIDE their or any other, their data is going.
well, so the homeschool must furnish school certify the academic if a student is ineligible for.
Which section are you guys in? I'm on the.
I am in, go down to H. Homeschool eligibility.
Well, what section is that in?
Section 1,
Section 1H.
right? Do you see it?
Yeah, sorry. Sorry, Anne, I know I'm probably taking more time than you anticipated with this one.
No.
This makes sense.
Honestly, yeah, we could be out of here in 30 minutes, Lori, but thanks. No, this is what this time is for. Really.
So they
Actually,
allow
can
for it
somebody-
under these
Right.
conditions, which is what Michael was saying.
Yeah, the Interscholastic League defers. So if the district allows participation, you can do that. If you don't allow participation, you can do that. The Interscholastic League says that if you're going to let your homeschooled athletes participate, then these are the criteria that your homeschool kids or the district needs to make sure that they're following.
And that's H4, to Michael's point. The school must approve the
Okay.
request of the whole homeschool student to compete. So it has to be somebody that has connections with us in some way.
Okay, as I read that, my concerns are abated, so I'm fine with the policy.
Okay.
Michael, you're okay with this? It's just, there are just a couple of extra hoops to jump through. And so the language of the policy should be, homeschooled student must comply with Interscholastic League rules, and then something about their plan, right? We have to include language about that, right?
Well, the Interscholastic League rules, and then we just, when we craft those plans, some are very simple crafting and can be a dialogue or, submit a Google form. Others, I get a straight up just certified letter. And that's the only correspondence, and all correspondence has to go through certified letters. But again, in most cases, those folks don't end up participating in Interscholastic League activities. So
I guess my question is for the language of the policy, which is, deceptively simple. We're adding any homeschooled student who wishes to participate in district athletics must comply with interscholastic rules. Should I add something that says participation must also be contemplated in either a homeschool plan, a homeschool request? Can I address it some way in this language or not?
could we say that Rhode Island, for homeschooled students, it would be the Rhode Island Interdepartment or the Rhode Island Interscholastic League rules or requirements supersede,
We have to comply anyway, right? We
No.
have to comply.
Right, but what I'm saying is my ability or Ken's ability or Casey's ability to get in contact with these folks to get us the things that the Rhode Island Interscholastic League says we have to have, we don't have the typical mechanism. We don't, hey, get us your last quarter's grades. What do you mean last quarter's grades? I get an end of the year grade. What do you mean attendance? We send a letter at the end of the year. So I'm just saying, even just parent contact in many cases, because I don't have updated email. They're not in Aspen. They're not going in and manipulating their data through the parent portal. So
Well, can't we set that approval for this? I mean, first of all, it needs approval. It's not just an automatic, right? A homeschool kid comes to whomever, Casey or Ken, or even Dave Tover, and puts in that request. What's the mechanism? What's the structure around that? Then it would have to really go through your office, Michael, because you need to set up the requirements under which a student can participate.
Okay.
Right? Isn't that what you're saying?
No, well, yeah, but it would also be, who knows? I mean, this homeschool request typically gets taken care of in August, September, and then let's say they, or they want to play hockey. Okay, I don't have all of the historical records on this kid. I don't have any records on any of these kids with the exception of the homeschool approval and plan. And then I don't have contact with them to get those prerequisite materials until they come and tell us or tell whomever that they want to participate in that. And then we have to go back and then backtrack and create all of these things because in order to make them eligible.
You'll need a separate form. Essentially, you need a form that says you want to do sports. Here's what we need. Check it off, and we'll consider it in granting permission. Right? Is that really? I mean, I know I'm oversimplifying because it's not that easy, but for the purposes of mechanics, is that what you're talking about? Kind of.
Yeah, that's what I'm talking about. But then in terms of, okay, so it's spring track. So let's say any of these now I want to participate in spring track. And now I've got to go back and get first quarter grades, first semester grades, attendance records, behavior. Just can't wait to suspend them from the track team. So, again, just creating the records that the Interscholastic League wants, we have to go and do.
Yeah, but you don't provide records to them, right? You just oversee them. You determine, you as member.
We've never approved homeschool, so no, we never provided any records.
Yeah, but even for it, yeah. So I think it's just a matter of the mechanisms in place to make it work. I mean, we really only, Chris Cobain, I spoke with him too. Well, I didn't, Casey did. And, he always felt supportive of approving it because they're minimal requests, 1 or 2 at the most. Ken, go ahead. Both Ken, full disclosure, Ken and Mike have been, what's the word I want to use? Engaged in the discussion on this matter.
Just to muddy the waters further, in Rhode Island fashion, we have 2 interscholastic organizations because of a years-old feud between the 2 organizations, and they have 2 different sets of bylaws. So I just linked the other one. And when you get down to section 15 on page 10, it says all athletes must participate with their school of record. It is not well defined as the Interscholastic League policy regarding homeschool. So I don't know what the read from RIPCOA is on that. Having served on the RIPCOA board way back when, it was deferred to an individual school kind of decision, but this language was present.
Yeah. I mean, I don't know if it's the same thing. We let our kids run as independent run. That's because that's what it was, but participate as independents at the middle level in other districts when we don't offer the sport. So we did a lot of track. We don't have spring track at the middle school, so they ran with other schools.
Let me ask a question. I mean, I see RIPCOA really is middle school level, right? Yeah. I'm looking at it now from that link. Interscholastic League is all secondary, but as a practical matter, for our purposes, it's really just our high school students. What interscholastic sports exist at the middle school level?
It's covered by
soccer, basketball, softball, and baseball, and cross country.
So just about everything.
Yeah.
Just about under what Ken referenced under RIPCOA, not the Interscholastic League.
My daughter's home from softball practice.
That's good. It's good that you went to softball practice.
It is good. That's why my dogs are barking. I apologize. So I'm just trying to look at, I've not seen RIPCOA. I'm trying to figure out what needs to be squared within here just for purposes of the policy. And so I'm just struggling with that a little bit.
I mean, the essentially ride in the policy in the communication via their website essentially leaves the decision-making to the individual LEA for quite a few things.
Is it enough to say then, so I've tweaked this, I'm not sharing my screen, and I know I'm not sharing on a Google Doc because it just is messy for this kind of stuff. I don't like it, but I've added, so participation in district athletics is open to all enrolled students and students residing in the 10 East Greenwich who are homeschooled in accordance with our policy and in compliance with the rules and regulations of the Rhode Island Interscholastic League. Right, and then where participation must be limited, preference is given to just those enrolled. And then any homeschooled student who wishes to participate in district athletics must comply with all district requests made for the purpose of compliance with interscholastic league rules. Does that make sense? And then but then I'm ignoring RIPCOA, and I'm not sure how to reflect that. I can share my screen, maybe that'll be helpful.
Allison has her hand up, I think.
Oh,
I
yes.
see a yellow hand. Yeah, I mean, I think.
Oh, yes, Allison, please, sorry.
Just through all of this, I'm simply, we started the conversation with Alexis saying that a lot of other districts did allow this participation. And I remember a conversation some time ago with a homeschooling group that talked about this. And so my question is just, how do those other districts do it? What do their policies say? What do they require? Because if they're already doing it, it may be worth it to just copy them if it's working. Not necessarily the operational piece, but just however they talk about doing it.
Yeah, I mean, I can certainly check with them. All I did was text my Southern superintendents and say, do you guys let homeschool students participate? And they all said they did.
You know, what we could do is, you know, we know that it's permissible. We just know that there are some bureaucratic hoops to jump through, some administrative hoops to jump through. So maybe and I've shared my screen so that you can see, you know, this is the new language. I could add RIPCOA, but what we could do is see if we want to go ahead and send this policy to the school committee for a first read, with the understanding that this provision will check out other district policies just to see how they kind of some more specific language, because we know it's permissible, we know it's possible. It's just a matter of getting the policy language right. What do we think about that? All right. We good with that? All right, so we'll send it up for a first read with a caveat, a little bit of work to do, tiny bit of work to do before that meeting, before April, whenever we put it up. Next policy then is 8220, interrogation of students by police. So this is just a mashup, if you will, of two existing but undated policies. One is interrogation and one is interrogation under exigent circumstances. Each of those policies is long, but does little more than just cite the statute. So Matt Oliverio just put together a paragraph long policy that covers both. He would like the actual, he created a Westlaw, just a 2-page that has all the statutory language that he indicated should be appended. We also have hyperlinks here. I added that next paragraph that says except under exigent circumstances, just to, I felt that it was appropriate to notify students and parents of their right to stop questioning and wait until a parent is present, except under exigent circumstances. I felt like that notice was appropriate to highlight. Questions, comments, thoughts on this?
My concern is just in terms of if the kid wants to talk to the police officer. So they're not being interrogated. I'm just curious. So before making the high school print, for the purposes of questioning, so, oh, I know some information. I want to tell the SRO, and we don't know if they're going to have, the police officer then having follow-up questions about, something that is student generated, not administrator or school generated. I just don't want to, and then that goes down. Well, how did you find that out? Or where did you hear, like, when does it become questioning, even though it's the student bringing things forward, where kind of like, wait, don't tell the police, we can't have this conversation until now I have to call your parents, where we were acting as in loco parenti beforehand.
But the law says that we as principals shall inform the pupil that they have the right to request his or her parent or guardian or an adult family member or person on the list of emergency contacts for the pupil to be present during questioning. So we're just informing them, and then they make the decision.
Right, and that's what this policy says too, right? Same thing? No?
Yeah,
It is. Yeah, it is. It's saying exactly that, and it's just the second paragraph is just pulling that extra piece out of it. But it's really it's exactly what's in the statute.
Yeah, I guess it just wouldn't be questioned for the available to law enforcement for the purpose of questioning. Maybe I'm on the I don't know, bouncing between the two docs. So
Yeah, I mean, if I'm looking at 1621.5-2 elementary students, for instance, before making an elementary school pupil available to a law enforcement officer for the purpose of being questioned.
yeah,
I mean, questioning is part of the is one of the words, was one of the it's part of the statutory language.
yeah, and I guess that asking a follow-up question to something that's brought to their attention is not an interrogation, or it's just a conversation. I guess at that point, if the student is bringing it forward.
My concern is, I'm looking at the document that's longer. I think they both say the same thing, but I'm
The older policies.
the older one, I guess, right? That has 2 or 3 pages to it
Yeah.
and multiple paras. And in there, it talks about a student 18 years of age, under 18 years of age. And I don't know how that translates into the new policy, but my concern is, of course, for students who may indeed be 21, between the ages of, I think it's up to your 22nd birthday, right, Alexis? If you are a student with disabilities, be educated up until your 22nd birthday. And so for a student who might be interrogated who is 19 or 20 or 21, that reads to me that we would not have to make that pupil's parent, we would not have to let that pupil know that his or her parents should be involved. Now, I wonder about cases where an IEP or, when, if at all, does that come into play? Because I could see students, we know there's disproportionality data on students with disabilities being, not necessarily for us, but nationally, being suspended, not understanding their rights, being interrogated, the police not having the skills necessary to interrogate those students. So I don't know I don't know if there's anything within special ed law or an individual IEP that would trump that, but it just seems important to me.
There probably is.
I mean, I would just add that just in the statute, the statute does contemplate, so procedure for interrogating high school students is, limited to under 18. That's carved out, but I don't know what special ed carve-outs exist.
I'm gonna look. I'm looking right now to see if there's anything.
Hi, this is Allison. And just in reading these, I went and checked most of the statutes, and it looks like the policies are pretty straight language, straight from the Rhode Island general laws. So
the old ones, and as well as this one, this proposed revision is just shorter and does the same
Yeah,
thing. But
no,
the old
that's what
one
I'm-
is, yeah.
But the language tracks pretty closely, it seemed to. So anything we add would be, that we're adding on ourselves, not anything that's prescribed, I don't think.
I mean, does this become a question of, well, no, it's a good question. An IEP. I mean, that's not going to be contemplated, but I mean, in
But
terms
does it need
of,
to be in an IEP, whether or not this would apply, like executive functioning type of thing? Is that what you're?
yeah,
it
you're
would be
talking
part
about
of
a
a
certain
student's
level of,
IEP?
like, a
I
certain
don't think
level
that
of
would be terrible.
like competence, to use like a legal term. Is somebody
Yes.
competent to
Yeah, I think that
withstand
would
or to
not be
speak on
terrible.
their own or whatever?
And I don't know if we're
And-
capable of making that distinction. I don't know if that distinction would be made within an IEP. And so there may not be any way around it other than common sense. Ken has his hand
Yeah,
up.
Ken.
Might have dealt with this.
Yeah, my only concern comes into those exigent circumstances. If you put it in the IEP, you are solidifying it by law that you can't do that. And my concern, okay, let's play out the scenario. A student who's 19 years old brings a weapon. We get knowledge that there's a weapon present somewhere in the building. We, under exigent circumstances, I want my SRO interrogating and finding out. How would that prevent the exigent circumstances from being enacted?
I think you'd carve out the exit the same way you'd add the writer, I guess, is what I'm going to call it right now, into an IEP. You'd have to carve out exigent circumstances, because I mean that's really what the policy is anyway. It's a carve out.
Is that the purview of an IEP though?
No, so I'm not suggesting we
No,
put language into an IEP at all. What I'm just wondering about is in the policy itself. We're saying that students under 18, right? We know, like by law, students under 18 right to have their parent there because they can't make all of these decisions for themselves, and they and their parents may decide we've got to have somebody with you before you are questioned and then potentially punished, and your words are now out there in the open. And my point is simply that we educate students who have disabilities up until they turn 22, and those students, I don't want to say I would treat a 19 or 20-year-old person the same, consider them a child or a minor, but I guess I'm almost saying something along those lines. And again, this is, I think, I don't know when or if those circumstances would come up. I want trust and believe that our administrators enacting a policy like this would say, oh, you're calling so-and-so to your office, and this child, look, I'm calling his mom and dad. He's going to be, or I'm telling him, why don't you pick up the phone? I think we need to call mom or dad now. If that child needs to be with us until he or she is 22, it's just, we could question a 19-year-old incapacity person with
yeah,
some
let's
level of diminished
narrow the
capacity.
question, right? We'll narrow the question. So what we're really talking about is, what about students who are 18 years and over, who might not have the same capability or capacity to judge for themselves whether or not they want to request a student present? And this is in under normal circumstances, not exigent circumstances. So there's no imminent danger, because under exigent circumstances, you don't have to call the parent. You got to deal with the danger, right? So we're talking about the non-emergency situations. And so the question then becomes, right, I'm just trying to narrow this group, this population that we're trying to address, and we may need to get more information and come back to it, and just to add a provision and figure it out. But Alexis has posted this flow chart. Alexis?
I put the flow chart in there from RIDE only because notice how they address it and they use it as special circumstances. So I don't know if we can incorporate some of that language, because if you notice in that flow chart, they talk about regardless of a manifestation of a disability or anything, if there are, you know, weapons, to Ken's point, or illegal drugs, then, you know, the matter takes a whole different approach.
Now, those are, one would argue, are, well, maybe not illegal drugs necessarily. Are those exigent circumstances? Sure. If somebody has some drugs on them that they could give to somebody else or use, you would consider that an exigent. I'd have to go back to the statute. So special circumstances in this flow chart is the equivalent to exigent circumstances, which means you take, parents come when they can, but you can proceed with the questioning.
Right. If a kid has a weapon, or you have a suspicion of that the child has a weapon on them, you're not going to, you don't have the luxury of waiting.
Right. So I wonder if we want to, you know, for just really articulate this question, which is, what about those kids 18 and over, right, under regular, you know, non-exigent circumstances? Is there something that we should put in a policy that addresses that, because these statutory provisions don't seem to?
So, Anne, what I would think is that in terms of the policy, like, we can be more restrictive on ourselves. We just can't, as long as we're fine. So the law allows us, you know, greater latitude with non-minors, 18 and older. That doesn't necessarily mean we as a district need to have a separate policy for those students. I mean, we could just simply say that barring exigent circumstances, we are going to inform a student who we instruct, who's enrolled in our school, that they could have a parent, or, you know, the same language that we have for non-minors. And that's our policy, because in exigent circumstances, we can, you know, question a 8-year-old if we need to. So I feel like maybe, even though the law distinguishes between minors and non-minors, our policy doesn't necessarily need to, and in regular circumstances it would apply to everyone from pre-K through whenever they're not enrolled anymore. And then exigent circumstances are exigent circumstances, and they apply pretty broadly to everybody also. And I think that might just make it easier, because then we're not cutting that distinction between capacity. Like, we're not trying to make like a judgment call on a student's individual capacity. We're saying, if you're a student and we need to question you, this is the policy, no matter how old you are. And if there's exigent circumstances, this is the policy. And, you know, let the circumstance maybe be the decider, as opposed to the individual child, student, perhaps. I don't know.
So let's try this then. I think that's exactly right. So if I change what I'm, so except under exigent circumstances as provided, I'll share the screen so we can see that, because it's easier. So except blah, 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 blah. So I just added this section for elementary students, because that's what this section addresses. And then something like, this is for all high school students, regardless of age, to ensure that parents have the opportunity, right? And that, I mean, because 16, this is where you get the age, the cutoff, under 18, but these are the steps outlined here, but we're adding all high school students.
And in the law, when they refer to elementary students, they mean elementary and middle.
That's right, and that's in this definition. That's in this definition section down here. That's right.
But once a student hits 18, they have the right to not have their parents be involved. We can't their legal rights to, I don't want my parents to know. I don't want my educational records or my disciplinary records being disclosed to my parents.
But I think, doesn't the language contemplate that? It says that what we're required to do is tell them.
Well, I'm just,
that they
I'm looking at it says for all high school students, regardless of age. So regardless,
well,
ensure that parents have an opportunity to be present for any such questioning. I don't want my parents there. I'm 18, I'm 19. I don't want my parents there. It doesn't matter what your policy says. We can't.
Right, but it says they have an opportunity.
Right. So
it's not saying that we must. Because I mean, the policy contemplates that if we call parents, even of little kids, and they don't answer, we can still proceed with questioning as long as we try really hard to get the parents, and the parents ultimately find out we question their kid. I mean,
So this
the
plays out-
statute and the policy that, as I read it, didn't like prohibit us from talking to anyone just because we couldn't get their parents on the phone.
So this is like a situation where a kid's 19, we're not sure of drugs on the premises or something like that, but we've heard rumors about it. They come down to my office. I'm talking to the kid. The police would like to talk to them about some type of investigation that is not immediate danger, exigent circumstances. I tell Johnny, before we're talking to the police, you have the right to have a parent with you. Okay, no? Okay, go talk to the police. Wouldn't it occur like that?
Yeah.
The kid's how old, Ken?
19.
Does the kid have a right to have a parent present? I'm just, I mean, if I'm a police officer.
But we're
and
saying,
somebody's 19, they don't have the right, they don't have the right to wait before I get to ask you questions. I gotta wait for your mom and dad. Or do they?
Therein lies the rub, what you try to figure out with school resource officers in school. How are they
Mhm.
operating and under what?
and
But we're talking about
You know, that's why
investigations that occur outside of school.
Right,
Send a detective over there, no, all of, carte blanche, and this is
exactly,
we're talking about the procedure and policy of what's placed in schools, right? Like,
right.
right.
So when the
So,
police
and that
officer says
can be
to you,
different.
like, can you go call Lori McEwen out of class? We want to ask her a few questions. Yeah, but I'm going to let Lori know that she can call her parents. If they want to ask me questions about something else and knock on my door or pull me over as I'm driving home or whatever, if I'm over
Mhm.
18, they don't have to inform anybody. But we're
I
playing.
mean, the question would arise then, like, let's say you did pull somebody, okay, Lori, you got pulled out, you're 19, you got pulled out for questioning, you said, no, I don't need to have my parents present. You have special needs, and you confess to something or say something that you probably shouldn't have, but you said, no, I don't need my parents present, and the parents come back and say, well, this our child Lori doesn't have the capacity to decide this, and does that put the district at risk?
How is that under the law, outside of the context of a school? What is the law for students with, or young people, not even students, people with disabilities, in the context of being questioned by an authority? Do they have?
They can
any
request an
other
attorney. They can
What?
request an attorney.
Yeah, but what if but I'm saying, what if they don't know, you know what I mean? What if somebody gets
Then they
arrested?
sue the police department.
Okay.
And unfortunately, like that, I know that. No, I'm not
No.
trying to be flippant. I mean,
No.
that's sort of why we have, and I'm not saying they're great, but why we have those protections in place, and why everybody is entitled to an attorney, and they have a right to not answer questions.
Right.
Also,
And
But
quite
does they
frankly,
have any protection
we
under
should
the
counsel
law?
that.
Right.
If you're a person that has limited capabilities, for lack, I mean, I want to make sure I'm using a respectful description.
Yes,
Do you have
yes,
protection?
they do. Yes, like those confessions, if they confess to something, most likely they would never be admissible as evidence against them for any reason if they were questioned outside the presence of a parent or guardian or attorney.
Well, I mean,
There's
if
a
you're talking about
whole body-
Miranda, that's like if you're in the custody, quote unquote, and custody is defined in a variety
I'm
of
talking more
ways.
just about contract law, like confessions and contracts. If you're found later to not have had the capacity to enter into that agreement, like those agreements are void.
right.
Yeah, but we're in criminal law. We're
Right.
in Miranda, so that's different.
And except that historically, folks have not sued, and
Right.
confessions have been admissible, and people have gone to death row with very limited. So that's
Exactly.
where I came from originally. Here, I do not want to be party ever, to sort of
And I
setting.
agree with you.
And I understand. I'm probably talking about something that, again, I think our caring administrators would say, I know all about Lori, and whether, even if Lori does not want to call mom or dad, I might be making a phone call in some way, shape, or form, or just telling the SRO, look, this is not a kid that can be questioned. But
And
so I'm being probably.
that's why. Oh, sorry. No, I don't think you are. And that is why when you brought it up, when I went and you're like, I wouldn't put it in the IEP, I'm not sure I 100% agree, because an IEP is designed, yes, as a learning plan, but it's also an encapsulation of the protections we afford to students. Like a 504 and an IEP, those are legally enforceable documents in order to make sure that kids are getting what they need in school. And so if we're running into this question where kids 18 and older could be in this situation, I'm not sure it is inappropriate that that kind of thing wouldn't be discussed by their family and their teachers and their IEP team about whether this would be a protection this child would need in a situation like this. I'm thinking about a friend of mine who has a daughter who is on the spectrum, and one of her biggest concerns is that, like, this is a girl who's not going to understand like sexual assault if it happens to her. And so if she's ever questioned about it, it might be wrong. Like, she doesn't, these things are things she's going to need to have an adult with her to talk about if she's ever in a situation like this. And that should, to me, I'm not sure it shouldn't be, that we shouldn't think about that in terms, I'm not an expert in any way, but from the legally, we're talking about police and questioning and legal rights and protecting the rights of these kids. That, to me, if the reason they need protection is because they may have a capacity issue, then that might be where it should be, because then it's legally enforceable no matter what happens in that situation.
Question, as a practical matter, how many students do we have 18 and over in our high schools? How many students are we really talking about, more or less?
You have an idea, Michael or Ken, about?
Well, it depends on how we're defining capabilities. I mean, that's really what it comes down to. I mean, I have 18-year-old students who have IEPs, and they're capable of understanding the essence of law and criminality. You know what I mean? So
so I think I'm getting at, like, how many students are we really talking about if it's an IEP thing, or something, like, just administratively, if we said, okay, except for, unless an IEP says, I'm trying to figure a way through this.
So I'm just wondering, I just wanted to say that I don't know that you would ever put something in an IEP like that, but what the kind of student maybe we're discussing is somebody who either has receptive or expressive communication issues in the IEP. It's not just any student, who is an LD kid or who has an IEP for another reason, but we're talking about a student who has a compromised ability to either internalize what's being said to them or to express themselves appropriately. So, I mean, I can't imagine it's more than a handful by the time we get to 19 to 22, if that, but I don't know how you would ever put that in a plan other than to say in a supplementary aid page that the student has communication issues, and know that you would act appropriately from there. But I don't know.
Can I just throw something out there? When would be the application where this type of circumstance would manifest? I'm not seeing it as an administrator ever, like, coming into contact. You know what I mean? Because we're talking about, all right, if it's an exigent circumstance, police is coming and talking to them. If it's an investigation of a previous incident in that school, and administrators talking to them, and the police aren't even involved. You know what I mean? So it's like, are we kind of predicting something that will never truly manifest within a school building? I'm not sure. That may be something, I don't know what I don't know, but I don't see that. I mean, even if it was an allegation of a sexual assault that was occurring with a student, we would be communicating with the kid's parent, unless the kid's parent was implicated in that right away. Depending upon the scenario, we'd be communicating with DCYF. So there's all these other circumstances. I don't think there would ever be a case where a police officer would come in and we would have to, for a 19-year-old, have to apply this policy in such a way.
So we pull it back to just reflecting the statute, basically, but putting that notice, because on the other hand, just in terms of risk and liability, if we do what the statute law says, that's our obligation to follow the law. Our obligation isn't necessarily to go above and beyond the statutory requirements.
And I think to Ken's point, certainly Beth, Michael, and I, whenever we've had to deal with anything like that, we are caring, and we would know, we would never, put children in a situation that would be, that they couldn't handle.
Is there a level of guardianship that's awarded for those who have, who are, by age, age of majority? Is there a level of guardianship that is extended? If that's because maybe it's just because my mind always goes to things, but students who, not that we try to keep all students, well, I'm not going to go off on a tangent of where else it could be, but a student who wants their own educational records and doesn't want things disclosed, or wants to sign out of high school. They're 18, they're 19. They, to what extent then do we not allow them to make that decision, or we have to decide that they are incapable of making that decision for themselves?
Have you ever had a kid that did that, Michael, on his own, just said, I'm not telling my parents, I'm signing out?
Absolutely.
And then what happens? Then does a parent?
Oh, they're 18. They're 18. They get to decide that. And that happens. It happens a lot when kids want to sign themselves out. Or that's the one that. And it's like, well, you can sign yourself. You can try and sign yourself out. Doesn't mean that I have to excuse you for the reason that you signed yourself out. But that's signing. Like, that's not removing myself or dropping out of schooling. So I was just curious. Is there, because we're trying to, protect, those who, are unable to make, or have been deemed unable to make decisions on their own. Is there some sort of, is there something that parents are awarded in order to continue to make those decisions for someone who's achieved the age of majority? If so, I would latch onto that. If not, then I just, again, it's tangential, but
I'm sorry, I got us rolling down this rabbit hole.
No, because I think while we don't want to prescribe how things are implemented, we have to think about how they'll be implemented when we're talking about what the policy will be if it creates some sort of issue. So, in saying, okay, our policy could be, we're going to call the parents unless it's exigent circumstances, that was more like administrative simplicity. And at that time, if a kid is 18 or older and they say, well, no, I don't want you to call my parents, then we would respect that unless there's a real reason, like impairment, which hopefully administration would know. But then we're not having like all these line item things in the policy. It's like, it's this district's policy that if somebody wants to question one of our students, we're gonna give them the opportunity to have a trusted adult, whether it's a parent, whether it's however it says. And if they're 18 and older and they waive that, they're allowed to waive it, but our default is we'll do it. Unless the student actively says no. That was more like an administrative ease sort of thing.
And just to clarify, this is just for police.
Yes. So here's what we've got. I think we came back to the beginning. I just added or guardians because it should have been in there anyway. Really, I just have we just pulled out from the statute this parent notification provision that exists by statute. I'm not even prescribing 6 through 8. I'm going to look at have everybody look at the definitions themselves. I think we keep it simple.
Yeah.
Having been through all of that. Oh wait, here we go. There, I shared it. Now I shared it. think that's it. Certainly we can, I'll run by, maybe Matt and Ray. We can run the discussion by them just to see if they have any additional thoughts, which we could certainly incorporate into a first read before the school committee. But that aside, are we okay with sending this up to the school committee? I'm seeing nods. Allison, yes. All right, so thank you. Thanks a lot, Lori. No, thank you. That's important. We have to discuss.
It is important. It is important.
It's very important. Imagine if I had pulled a different provision out. We could have been here another couple of hours. That's just the one I happened to pull. You're welcome. Okay, the next one is the, I have to pull this one up, the teen dating and sexual violence. This was initiated, I'm going to pull it up myself. Initiated, as you all are aware, we're looking at our sort of anti-discrimination and harassment policies, anti-harassment. District-wide, they need an overhaul. They need to be aligned with one another. There's a lot of work that needs to be done. So we've looked at some of them. As I'm talking, I'm stalling because I'm trying to find the version I want to look at. Anyway, this is another piece of that. Matt Oliveria suggested that as long as we're looking at Title IX, which we did at our last policy committee meeting, we should be looking at this as well. And so he recommended that we create this policy. Now that said, this is a draft. I think that Matt Oliverio's associate drafted it. It was initially drafted to impose on the district an investigation obligation that exceeded really the appropriate scope. It was not limited to just instances that may have occurred under school or district purview. So I tried to narrow that a bit in this draft that you see before you, and tried to streamline it a bit. So really, it's the essence of what Matt and I think his associate sent to us. So. And as I read it, and anyway, I'll let you discuss. As I read it, it imposes, there's an obligation imposed on anyone, not just schools in particular. And so this policy outlines, I included the scope of the policy. There's a certain reporting and investigation. I think that we're advised we are to follow. Anyway, thoughts? I know, Michael, you had some initial thoughts and concerns.
Yeah, just just because of the most recent happenings and the trainings being issued by DCYF, they do not want schools doing any sort of investigation, even with the best of circumstances, because ultimately we could end up poisoning the well or giving people a heads up. So if we believe that there's been abuse or something that would fall under DCYF purview, that we make our obligation is to make the phone call and they do the investigation. And we are not to take any action or take any investigatory action. If so, we could be held liable.
Is this an instance of something within a family happening within a family unit? Is that, I'm assuming that's distinguishable from, one child to another. I mean, I'm not understanding. I guess I'm not understanding the intersection of if you've got two teenagers where this might arise, right? Like a true teen dating situation. Let's say they're at a high school football game and there's an incident that occurs during a school event. That puts it within the scope of this policy. But is that a DCYF? Does that implicate DCYF?
You always have to make the call.
Okay.
You always have to make the call. And they, to Michael's point, and they determine whether it's an investigation is warranted or not. I mean, and depending on the circumstances, you would want to inform certainly families if that were the case, depending on the circumstances. And then, the police matter becomes a little, I would always defer to the guidance from DCYF. You call up DCYF and you say X, and you say, let them, if you feel that the police should be involved, I would ask them the question, are you informing the authorities? I don't know what Michael and Ken think about that, or Beth for that matter, with any kind of situations but they were really clear in fairly recent trainings that they're going to do the investigation.
Then they became unclear as time went on, and they got
Yeah.
to meeting the road regarding such investigations. So because then we would call nonstop about everything that was occurring in schools, especially with 2 16-year-olds that we became aware of something, and they said, we have nothing to do with this. So it gets a little murky at the high school level, because when you have a report of 2 16-year-olds where something happens, it doesn't fall under the purview of DCYF. It becomes a police matter at that point.
Between 2 16-year-olds?
Well, then it would become, if all of a sudden I call DCYF and they don't take any action, then I would say, and if all of a sudden there's an assault or it's somebody being in danger, then it's my obligation to go and tell the parents at that point, because they then they're in charge of making they have the legal recourse of what they're doing. Now, then based on the information that I have regarding that, and if DCYF has been, involved already, or there's a reason for the schools to know about this, or if we have knowledge of it, obviously it's something that has spiraled out of control, or something that needs our attention, because it's at the school's level. So therefore, we can follow up on those aspects, but only after DCYF has been told. And then at that point, if we believe that there's been a law broken, we would tell the parents and then inform law enforcement.
So what I'm hearing is procedurally something happens, right? You have to alert, you might have to alert the police right away, depending on what it is, and you have to report to DCYF. And then you let DCYF tell you whether it's within their purview or not, essentially. And then there are other implications at a school or district level. And then is that really when the supportive measures come in? Or if DCYF says has nothing to do with us, then it becomes an administrative issue, administrative and or criminal issue. I mean, so that's it's who owns it. Is that what I'm hearing?
Yeah, I think a ton is in the context. I mean, obviously, if it's something that, let's say, a sexual assault at a school dance, and between an 18-year-old and a 16-year-old, or a 15-year-old, that's one level. That's a couple different layers. That's usually DCYF, the police at the time, and it's happening as a school event, and so at a school-based function. We also then, more commonly, it is the going to the guidance counselor to disclose some information. It's not happening at school, but it's brought to the school's attention. We now know about it, and it's the stress of that situation, or there's somebody in danger, or the stress of that situation is making it so that the student can't be a student because they're in fear or because they're dealing with trauma. Okay, now it's really,
well, that's when the supportive measures kick in, right? So I think the area that's in question seems to be the investigation piece. The reporting piece seems clear. it's the investigation piece, if we can narrow it, because the supportive measures, all make sense, regardless of who owns that piece of it. Even if it's DCYF, if faculty or administrative counselors are made aware of something, then that's something that school administration can work with and adapt some supportive measures around that, probably, right? Disciplinary sanctions, well, if it's not within the district purview, then disciplinary sanctions don't apply. So really what's in question, it seems to me, and I mean, correct me if I'm wrong, is what we're really looking at is the investigation piece. Is that, and I mean, and then everything else I'm sure should be refined, but that's the piece that we really need to sort out.
Yeah, as
Does
well
that
as,
sound right?
yeah, as well as then because I think we're in the middle of doing our complaint resolution procedure, aren't we? In the middle of,
Yeah, we're figuring out where that's going to go. If it's going to remain, if it's just going to be part of discrimination harassment, if it needs to be continue to be highlighted as a standalone policy, and then say this is, if under this policy you need to raise an issue, then see the complaint, then the complaint resolution. You know, we're going to put all those pieces together at a subsequent policy committee meeting, because the other policies we looked at last time need more work. And all of these need to be looked at as kind of a bundle.
You know, the issue with this is that you must be responsive. So, as we're saying, so you must report to DCYF. If something is brought to your attention as a building administrator, how you must respond in some manner, even, you know, to protect the child, you know, or children in the situation. So, you know, investigation of a situation is different than investigation of a potential criminal matter, right? So I think that's what we're trying to distinguish, I think.
Well, we're trying to distinguish, okay, so what are we talking about? If we're talking about, let's take the example of, you know, something that happens at a school dance, right? There's the obligation to, and depending on the severity, it might need to be reported to police, right? Depending on the circumstance. I'm hearing that it must be reported to DCYF because it's a minor, no matter what, they get everything. And then DCYF will have to say, okay, this is ours. This is DCYF or it isn't. So either you, the school and district, are free to investigate, or it belongs to us, right? So that's the investigative piece. Beyond that, then there's the potential, if it does fall within the purview of the district, then the district and school must investigate, right? And then perhaps provide supportive measures and perhaps impose disciplinary sanctions.
So
is that kind of the framework?
Yeah, so in the context of this, you know, teen dating, violence, and sexual assault, is there anything, you know, violence and that would not border on being a police matter?
right?
That
and
was
that's-
my question.
Right. It's a police
Does it
matter.
matter how old they are?
Right, and I don't want to get in the, and what I don't want to do is, or my designee get in the middle of investigating, and that's why DCYF has a stay out, because we don't want to get in the middle of another active investigation. Yeah, we might have tools and come up with certain things that law enforcement doesn't have, but once again, poisoning the well or questioning people before law enforcement has an opportunity to get there.
Yeah, and my investigation meant like a kid comes up to you and says, Mr. Pedraza, so-and-so did this. You're going to ask a few questions, right? You're going to try to understand the situation.
Yeah, but if I believe a crime has been committed, especially at this magnitude, it's going to be immediately to the police and to the parent and guardian, assuming that and then if need be, you know, or if conditions warrant with minors, DCYF.
And
We're
remember,
talking high school level, but what about at the elementary level? Does that
So
a
I
police
think-
matter?
I guess it would all depend, but we make plenty of those calls at the elementary level, but I would say that we're investigating them and then deciding whether or not we're making the call to DCYF. Or if it's anything of sexual nature, sometimes we're just calling to say, I don't think you really need to know about this, but I just want to run it by you so you can decide if you want to investigate this further. That's really what it looks like from our end. And right away they know when it's administrators calling, especially of lower elementary, because sometimes it's about the boy in the bathroom who showed himself to the other boy because he thought it would be funny. And you just need to follow up with DCYF to make sure that nobody feels like anybody was assaulted in that incident.
And then conversely, you have, you have a student, a freshman, let's say, and the age of consent in Rhode Island is 16, and that freshman is 13 years old, and you have a 18-year-old senior. That's problematic. To use not the most correct term. So, I mean, it goes from one gamut to the other.
Yeah, and are you guys saying that DCYF is saying you call DCYF about that and not?
Yes,
Not the police.
you have.
'Cause
Yeah,
that sounds like potentially statutory rape.
I know.
Yeah.
I mean, they'll probably advise you call the police, but I mean, in either way, it depends. It depends on the situation where you would determine.
I was just gonna say, it might depend on which call you're making first, but both of them are getting made.
And how you're getting the information. A student coming up, a student, I've heard this, or
Yeah.
so-and-so's, secondhand information. A lot of time with DCYF, because like DCYF told to us, you want to call us because you also don't know how many calls we've gotten about other people, or how many times a student has been called on, or at an earlier school, or at an earlier grade, or with a different case. So
it takes the, whether it's like a second or third hand, you might not know how credible it is, but DCYF will.
right, like if they've got a case, or if they've got something already running, they're not going to disclose that to me usually.
Right.
But I'm going to report it and then move forward, because again, I don't want to go and say, well, let me go see if this kid is telling the truth before I find out, and then in my investigation somebody else finds out about it and goes and runs and tells the kid. And then, again, it's just that good intention of trying to protect, where then we've let something out of the bag, and then any subsequent investigation that needed to happen by Child Protective Services can't occur with fidelity.
Yeah, and it is so contextually significant, because if a child comes to you and says to you, my father does X, you have to go to DCYF right away, because you have to, whatever criminality comes out of that, I don't know, but that child needs to be protected. And you're not going to call the parent up and say, I called DC. It depends on the situation, but you're going to make sure that child's protected.
Mm-hmm. So it seems to me that there's some work to do just in the policy itself, in clarifying all of that in terms of steps and sort of purview scope. That I don't think we're going to necessarily get to. It's helpful just to talk about it in theory, because knowing that we're going to look at this again, just in terms of how this might work. I mean, I think the way this was initially drafted and contemplated, it was that, certain administrators, if it's within the school or district purview, certain administrators will deal with it. Or if it is something under a Title IX policy, then the district Title IX coordinator would deal with that. And it just seems to be it seems to have a more of a bureaucratic layer on there that I think we need to look at when we really look at the Title IX policy, when we revisit that.
Yeah, It seems to me that our confusion is about clarifying the investigation piece.
Yeah.
You know, like what are you, what matter are you gonna, at what level are you gonna look into it as an administrator, and then, you know, and then at what point do you report to DCYF?
Right. It should just say, you know, here's how anybody can report to administrators in the district, and the administration must report to DCYF as a threshold issue. And then DCYF will tell us what to do. And if it's ours, this is how we proceed.
Yeah.
We're not doing anything with this. I don't think we're going to revisit this with the other policies, I think, because it's helpful to look at them all together. Additional thoughts on this?
Yeah, just based on what Alexis was just saying about, you know, if a child comes to you and says something about their father, but the policy I thought said it just dealt with activities that, the events that take place, like on school property,
true.
obviously, but then at school sponsored, which I was actually curious about, because I would think that our obligation to report would be any credible anything, regardless of whether it happened at school. And so I was wondering why we carved it out. And if this was supposed to just be the teen dating and violence, I was based on our conversation, I'm a little confused.
I'll clarify. So I think initially it was this investigation piece that I was trying to sort out. There's some comments in there. I understand the reporting obligation, but we also needed to put the scope in terms of sort of the investigative piece. Because let's say it goes to DCYF and they say it's, I mean, I don't know. I would have to play with that a little bit, because I didn't quite appreciate the investigative piece. And, you know, comments back in this seem to indicate. So I want to clarify that in the policy a little bit. That's another piece that has to happen, because initially, as the policy was drafted, it was the district's obligation to investigate everything. And I knew that wasn't right.
And I just wasn't sure if it was just, you know, if DCYF says it's not theirs, it's not ours either, unless it happens at some kind of school sanctioned something, which would seem a little strange to me. If you've got students coming and the people they feel comfortable telling this to are school administrators, and then they say, well, if it didn't happen at school, I can't help you, which doesn't seem to be what we're about at all. And then second, I will cop to not having read all the full statutory sections. I didn't know if we have like a Good Samaritan penalty. Like if we investigate and then it turns out to be nothing, is the school, you know, I didn't know if there was, especially around like minors or statutory rape or any of those things, if there's, you know, that Good Samaritan penalty that laws sometimes have, like as soon as you step in, now you have to fix it, and if you don't fix it, they can sue you, kind of thing. I didn't read to see if there was that for schools, so I didn't know if maybe that was why we were limiting our scope. But based on this conversation, I was uncomfortable with it at the beginning, and now that we've talked, I feel like limiting it to just the very school specific events. If you've got a teen or a kid who comes to their teacher or their principal and, you know, report something like this, and it's not within our like it's not DCYF's, we wouldn't, I don't know if you, and it wouldn't be something we call the police. Yeah, it seems very odd that we would sort of just be like, it's not our thing if it didn't happen at school.
I hear it. Yep, I hear you. We need to tweak that, because again, that carve out came from the investigative aspect of it, because it was overly broad as drafted. So, and then, you know, we would want to take a look at, you know, supportive measures as well.
Yeah.
So this also, Allison, you probably know this because you've done all of your homework exceptionally well for every piece of this, but this policy is connected to the Lindsay Ann Burke situation. And that's, you know, her mom, you know, fought passionately for this in the law. And what her situation was, that the mom knew, you know, about the relationship with the boyfriend and had tried to intervene, but was unfortunately not successful in the end. And she wants people to be educated and knowledgeable and paying attention to what content potentially could be.
And no, and I absolutely agree. And I think the focus on teen dating violence and sexual harassment, I mean, we've seen a lot of this over the last several years with Me Too and things like that, with the Stanford case. A lot of issues I think we see with adults now are from not directly teaching and addressing these issues with our kids when they're learning about these kinds of things, about relationships, about sexuality, about all of these things. And patterns start forming when you're teenagers that then people brush off and then are not okay when you're an adult. And so, you know, actually focusing on them, taking them seriously, having really strict policies about what is okay, what is not okay, what either or any gender should tolerate from another when it comes to intimate relationships. As much as that's so hard and weird to talk about in our society for a lot of people, so much of that is what happens at school, is the formation of these things. And by having a really strong, just the way we came out when that incident happened with Rhapsody in Black, the statements that you and that Mr. Hopkins, they were so like unequivocal, like this is okay behavior and this is not okay behavior. Same kind of thing here. And I do think it's important to do that. And that's why I would hate to see it just carved out for just if it happens at school. In the same way we're dealing with racism. Like, violence is never okay. You shouldn't think it's cute just because, like, when a 14-year-old boy or girl does it, it's cute. But when they're 25, it's not cute anymore. So it's not okay. Like, all of those kinds of things are wrapped up in that. And I think it's really hard to know, like, when it's criminal, when it's not. I don't have the answers to that, but I think it's important for us to have policies around it, because what we teach them now in 5th grade, in 11th grade, you know, is what they'll carry with them in all their relationships. And so, you know, it's a really hard topic, but it's really important. And it's just yet another layer of things that you all have to deal with every day on top of everything else that you deal with. And I know you all care so much that you're not going to let anybody be hurt if you can help it.
I mean, this begs the question. These are really good points. It begs the question. So as I understand it, you know, we're 3 minutes out from 5:30. So I think we can stop. No, don't be sorry. This is an excellent point, which is what we might want to contemplate for next time, is that I don't think that there's a requirement to provide, you know, this sort of training, awareness, et cetera. There's not a requirement, but it's certainly recommended and there are resources available. So we might want to contemplate whether we want to, you know, mention that, impose an obligation on the district to provide some awareness training and education or not. But that's something to think about for next time. And just again, that carve out was really to address the investigation piece. I don't disagree at all. So
Yeah, we do have to teach it in 8th grade.
we do.
Part of the health curriculum. So
I knew it was in there somewhere.
Yeah.
Ken,
go ahead, Ken.
it is.
In the high school.
And the high
Can
school too.
somebody shoot me an email and let me know what that obligation is and kind of what we do? I mean, what under what authority? I mean, what's the
Lindsay and Burke Memorial Act,
Yeah,
right? Ken,
Memorial
it's
Act.
Lindsay
I'm
and Burke.
looking at it now and I'm seeing it. It's and then it's 1685 1 and 2. So I'll just have to take a closer look at that.
And then just one
because-
final comment before we go. My point to you, Allison, was, you know, this probably needs to stand alone as the dating and sexual violence policy, and then the other matters that we're talking about fall in our other policies, I think.
Yeah. And yeah, I think
Depending.
it might be good
Yeah.
to carve it, just because it's serious, and having it be separate sort of, you know, shows that it is a serious thing. And I'm not trying to say that, like, there's no you know, I don't use that kind of language, but, you know, so much of that policy, having it, is what you're talking about, but the educational piece. So that's the most important thing, you know. But how we the stand that we take it through policy about these issues, I think says a lot. So
I mean, it
I'm
does
glad
say
we
just
have
that
one.
yeah, well, we will have one very soon, right? And which I think we're supposed to have had by 2008. So it does intent legislation that would require district establish a policy and to provide for responding to and to provide dating violence education to students, parents, staff, faculty, and administrators in order to prevent dating violence, specifically dating violence. So
Dating
it
violence.
does go, it does, that's what 1685-2 says, and to address incidents involving dating violence. So it's something that we need to, it's not in the references that our council provided on this policy, but it's something that we will revisit when we look at it next time. And it's exactly 5:30.
Good job, everybody.
Thank you all so much. I know there's a lot going on. I appreciate it.
All right, have a
Take
good
care.
night. Enjoy the nice weather.
Thank you,
Too.
everyone.
Bye, everybody. Thank you.